Breaking news for every gun owner and driver in America. The Supreme Court of the United States just handed down a unanimous 9-0 ruling that is going to change how millions of Americans carry firearms in their vehicles. And when I say unanimous, I mean every single one of the 9 justices agreed. That almost never happens. When the court is that unified, it means something significant has fundamentally shifted in the law, and you need to understand exactly what changed before you get behind the wheel again. Because the consequences of not knowing this could mean losing your firearm, losing your driving privileges, and facing felony criminal charges that follow you for the rest of your life. Hit that subscribe button right now and turn on notifications, because in 2026, ignorance of this ruling is not just a mistake, it is a fast track to a life-altering legal disaster. Let us start with the single biggest source of confusion already spreading across social media about this decision, because people are getting this completely backwards, and it is dangerous. When people hear a 9-0 Supreme Court gun ruling, a lot of them immediately assume one of 2 extremes. Either the court just made it totally legal to carry anything anywhere in your vehicle with 0 restrictions, or they think the government now has a green light to confiscate every firearm from every car in America. Both of those interpretations are wrong, and believing either one is going to get you into serious trouble. Here is what the ruling in Barnes v. Felix actually does. The Supreme Court has clarified and in some critical areas significantly expanded the legal framework around how the Fourth and Second Amendments apply specifically to firearms kept or transported inside private vehicles. Justice Elena Kagan, writing for a unanimous court, dismantled a narrow legal standard that had existed in several federal circuits called the moment of threat doctrine. Under that old rule, when courts evaluated whether law enforcement acted appropriately during an encounter, they focused exclusively on the precise second force was used or a weapon was drawn. Now the court has replaced that narrow window with what legal analysts are calling a totality of circumstances standard, a wide-angle lens that looks at the entire timeline of an interaction from the very first moment it began. Why does this matter to you as a gun owner in a vehicle? Because it changes the legal calculus of every traffic stop where a firearm is present. The court is no longer asking only what happened in the final moment of an encounter. It is asking what the entire sequence of events, your tone, your movements, your disclosures, the context of the stop, looked like from beginning to end. That shift has profound implications for how you should conduct yourself from the second you see blue lights in your rearview mirror, and it makes the next 10 things I'm about to tell you more important than ever. The first thing you need to understand is what is now called the Glovebox misconception, and it catches responsible gun owners every single day. A significant number of American gun owners believe that as long as their firearm is stored in a glove box or center console, they are legally protected regardless of what state they are driving through. That assumption was already legally questionable before this ruling. Now it carries even greater risk. The Supreme Court's decision makes clear that the Constitution protects your right to have a firearm accessible for self-defense in your vehicle. But that constitutional protection does not override state-level requirements about how that firearm must be stored, whether it must be unloaded, whether ammunition must be kept separately, or whether you need a specific permit to have a loaded firearm within reach. In states like California, New York, Illinois, Massachusetts, and New Jersey, you cannot simply place a loaded handgun in your glove box and drive. Those states require firearms to be unloaded, stored in a locked container separate from the glove box, and in most cases you need a specific carry permit just to have a loaded firearm anywhere in the vehicle. This ruling sets a constitutional floor, the minimum federal protection, but it allows states to build walls above that floor. If you have been driving around with a loaded firearm in your glove box, assuming you were automatically protected, you need to verify your state laws right now before you drive another mile. The second critical thing is understanding what concealed carry permits do and do not protect. A concealed carry permit issued by your home state gives you specific rights in that state and in states with reciprocity agreements. It does not give you a blanket authorization to carry a loaded, accessible firearm through every state you travel through. And the Supreme Court's ruling, while affirming core Second Amendment protections, made explicitly clear that interstate travel with firearms involves a patchwork of state laws that still apply the moment you cross a state line. If you live in Texas, carry a Texas license to carry, and decide to drive to New York, you cannot carry your firearm in the same manner in New York that you do at home. New York does not recognize Texas carry permits. The moment you enter New York with a loaded, accessible handgun in your vehicle, you are potentially committing a felony under state law, regardless of what the Supreme Court affirmed about the Second Amendment. This is not a hypothetical. People are arrested for this every single year. The ruling does not change that dynamic. Know your reciprocity agreements before you cross any state line with a firearm in your vehicle. The third thing every gun owner must understand is how the Barnes versus Felix ruling changes the practical reality of a traffic stop, and this is where the totality of circumstances standard hits the hardest. The court reaffirmed that the mere presence of a legally owned and legally transported firearm in your vehicle does not by itself give law enforcement grounds to detain you or search your vehicle without consent. But under this new standard, everything you do from the moment sirens turn on becomes part of the legal record. Here is the single most important protocol you need to memorize before your next drive. When you are pulled over, pull to a safe location, turn on your interior dome light if it is dark, and keep both hands visibly on the steering wheel at the top. Before the officer reaches your window, roll down all windows. When the officer arrives, use this specific approach. Calmly inform the officer that for their safety and yours, you are a permitted carrier and there is a firearm located in a specific location. Name exactly where it is. Then immediately clarify that your hands are staying on the steering wheel and ask how they would like you to proceed. By placing the How to Proceed instruction on the officer while keeping your hands in plain view, you are building a documented record of full compliance that becomes extremely difficult to characterize as a threatening totality of circumstances. You are not reaching. You are not creating ambiguity. You are giving law enforcement every tool they need to de-escalate the situation while simultaneously protecting your legal position. There is an important nuance here that catches well-intentioned gun owners off guard. Know before you drive whether your specific state requires you to proactively disclose a firearm to law enforcement during a traffic stop. Some states require immediate disclosure. Some only require you to answer if asked. Some have no disclosure requirement at all. If your state requires disclosure, and you do not disclose, that is a criminal offense entirely separate from any firearms charge. Ignorance of that distinction is costly. The fourth critical issue involves the constitutional carry states, and this ruling adds significant weight and clarity to what constitutional carry actually means for vehicle transport. In states with constitutional carry laws, places like Texas, Florida, Georgia, Arizona, Tennessee, Montana, and more than 24 others, adults who can legally own a firearm can generally carry concealed or openly without a government-issued permit. The Supreme Court's ruling provides stronger federal constitutional grounding for vehicle transport within those states, and law enforcement in constitutional carry jurisdictions now has clearer guidance that a visible or accessible firearm is not by itself probable cause for a search or detention. However, and this is critical, your constitutional carry rights exist within your home state's legal framework. The moment you drive across the border into a state that does not have constitutional carry and does not recognize your home state's protections, which includes most of the Northeast, the West Coast, Illinois, and others, those protections do not travel with you. The Supreme Court's ruling does not create a national constitutional carry standard. That misunderstanding is going to cost some gun owners dearly in 2026. The fifth thing to understand is the vehicle ownership distinction. The constitutional protections the court affirmed apply most clearly and most strongly to your own private vehicle, a car you own or have a direct long-term personal interest in. The legal picture becomes significantly more complicated in vehicles you do not own. Rental car companies almost universally prohibit firearms in their rental agreements. Bringing a firearm into a rental car may violate your contract in addition to creating legal exposure. Rideshare platforms like Uber and Lyft explicitly prohibit firearms in their vehicles for drivers and passengers. Company-owned vehicles are governed by employer policies that may prohibit firearms entirely. The Supreme Court's ruling does not override private property rights or private contract terms. Your Second Amendment vehicle protections are strongest in your own car. The sixth thing concerns long guns, and it catches people off guard because most of the conversation around firearms in vehicles focuses on handguns. If you own a rifle, shotgun, AR platform firearm, or any other long gun and transport it in your vehicle, the rules are often entirely different from handgun transport regulations. In general, rifles and shotguns must be unloaded when transported in a vehicle in most states. In some states, they must be cased or otherwise not immediately accessible. The Supreme Court's ruling clarifies that constitutional protection for vehicle transport applies to all firearms, not just handguns, but it also affirms that states retain authority to regulate how different types of firearms are stored and transported. If you are driving to a hunting location with a rifle in your truck, the specific requirements for casing, unloaded storage, and actions depend entirely on your state law and the laws of any state you pass through. The seventh issue involves a critical ruling from the Supreme Court in Bondi v. Vanderstock that upheld the ATF's authority to regulate so-called ghost guns and parts kits as traditional firearms. The court ruled 7-2 that certain parts kits and unfinished components clearly qualify as firearms under federal law, which means that if any component of a firearm you transport lacks proper serialization under current federal marking requirements, you may be facing exposure to federal charges. If you have modified your firearm with aftermarket parts, or if you built a firearm yourself, you need to verify that every serialized component meets current ATF requirements before transporting that firearm in your vehicle. The hobbyist era of informal car carry is over. If your firearm is not fully compliant with current federal marking rules, transporting it in your car creates serious federal legal risk. The eighth thing is about your personal legal history, and this is serious. The Supreme Court's ruling affirms vehicle transport protections for law-abiding citizens. Those three words carry enormous legal weight that directly affects millions of Americans who may not realize their past creates restrictions this ruling does not remove. A felony conviction means you cannot legally own or possess a firearm under federal law. This ruling changes nothing about that. A domestic violence misdemeanor conviction creates a federal firearms prohibition. This ruling does not touch that either. If you are subject to a qualifying restraining order, you cannot legally possess a firearm. If there is any question about whether your legal history affects your right to possess a firearm, you need to consult a licensed attorney in your state before placing any firearm in any vehicle. This ruling provides protections to people who are legally entitled to carry. It does not provide cover for those who are not. The ninth thing addresses the states that are already pushing back, and this matters enormously for your day-to-day life. When the Supreme Court issues a ruling, it does not automatically transform into uniform enforcement overnight. States like California, New York, New Jersey, Massachusetts, Illinois, and Hawaii have a documented history of passing firearms regulations right up to the constitutional edge, and sometimes beyond it, forcing further legal battles. After this ruling, those states are already signaling they intend to comply with the letter of the decision while preserving as much restrictive authority over vehicle transport as their legislatures believe they can maintain. What this means practically is that in high-restriction states, the day-to-day experience of carrying a firearm in your vehicle is not going to change dramatically because of this ruling. Enforcement is local, prosecutors are local. And in jurisdictions with aggressive prosecutorial cultures around firearms, the Supreme Court ruling is not a get-out-of-jail-free card. Know your local law. Know your local enforcement environment. When in doubt, consult a licensed firearms attorney before making assumptions about what this ruling permits in your specific jurisdiction. The 10th and most important takeaway from everything covered here is this. The Supreme Court's 9-0 ruling has shifted the legal landscape, but knowledge of it means nothing without action. The worst possible response to a legal shift of this magnitude is to assume you now know exactly where you stand and stop paying attention. Here is what needs to happen in the next 30 days. First, look up the specific firearm transport laws for your state right now. Not what you remember reading 3 years ago. Not what someone at the range told you. The current law as it stands today. Second, if you regularly drive through other states with a firearm, look up the laws for every state in your travel pattern. The difference between a legal transport and a felony arrest often comes down to a single state line. Third, if you have any legal questions about how this ruling affects your specific situation, your history, your permit status, your state, consult a licensed firearms attorney. The cost of one consultation is nothing compared to the cost of a criminal defense. Fourth, make sure every firearm you transport is properly stored according to your state's requirements every single time you get in your vehicle. The one time you get careless about it is the one time it will matter. Knowledge is the only thing that genuinely protects your rights in this new legal environment. Share this with every gun owner you know. Drop a comment below telling which of these points surprised you most. Was it the state reciprocity issue, the rental car situation, the new totality of circumstances standard, or something else entirely? Stay legal, stay informed, and stay safe out there.